I gotta, hold on. I'm usually not a microphone guy. And it's always a fine line between being heard and not overpowering, I think. Thanks for the introduction. Most of that's true. Maybe just as a little bit of background, as he mentioned, my background is in intellectual property, which is helpful to a lot of businesses. But I thought it'd be helpful just as a little bit of a background. So I come from a family of entrepreneurs, and it's interesting as you grow older and you learn about your parents and you realize what they were doing. And now that I'm in the position they were, I think, boy, I would never do that. But for example, my grandpa was with what was then a small company in Eastern Oregon, Western Idaho called Ore potatoes. He was with a couple of his cousins, and they started the business, and he sold his house to put a bunch of money into the company, and that's what they did. But they do a lot of potato products. Anyway, but it was just a couple of years ago that I learned that he had sold the house so he could put it all in this company that he started up. So a little bit more appetite for risk than maybe others may have. My grandpa on my other side, he had an international equipment, they make tractors, dealership. And then my father, growing up, he was an importer. So he'd find products that people needed, and he'd import them from the Far East, from Japan, Korea, China back in the day when we didn't import a lot of things from China. And he also had a real estate business, and so he was always acquiring properties and renting out properties. And so as a kid, I always felt like we had nothing. It wasn't until later that I learned that it's because my dad was taking all the money he had and putting it back into the business. So if I look back on my upbringing, I think one of the things that I owe to my parents is thrift, and the idea of, really he was bootstrapping his business constantly. So when I was in high school, I wasn't a farmer, but I sold, now let's see, I got to point this. There we go. Okay. So when I was in high school, I was actually working for my dad as a plumber. And you don't make very good money working for your dad, unless your dads are different than mine. But it was okay. And my aunt actually, and she kind of had this entrepreneur, she was actually importing things too. And my cousins had worked this up in Holiday, for those that know the Salt Lake area, and they said to me, and my dad, they said, this is incredible. We got this business idea, we can make $100 a day in the summer. What we do, and they told us, they were real nice, they said, look, we just want to do it at our two places, but we drive up up by Hill Air Force Base. There's a farmer we know. We buy the corn. We bring it back down. And corn, if anybody knows about sweet corn, it goes bad in about 24 hours if you don't refrigerate it. So he said, it's great. You just get a few boxes, come down. You can make $100 a day. And then you go home. And they said we go water skiing at noon. And so we got the idea from them, and they were fine with us doing it. They recommended we do it. And so we set up one stand, my brother and I. And the first day we sold out of corn. We just set up, made some signs that said corn. And we sold it fast, and so the next day we set up more stands, and we borrowed my dad's pickup, and then I gave him my 2-week notice. It was more like a one-day notice saying, so I'm done with the plumbing, I'm doing corn. But he was good enough to let us use his truck and trailer, and then this is just a picture. So we had the pickup and a trailer, and then within a couple weeks, we realized there's a lot of corn we're selling. We could sell tons of corn. We had like 7 stands after a week, and so we got a credit card. My brother got, and then we bought a big truck with that, and then he was just off his mission. So he was old enough that they sent your credit cards in the mail. I don't know if they still do that now. But we did it, and we bought a truck for $2,500 on it, and we paid it back in like 2 days with revenue. So anyway, it turned out to be a pretty good business. It wasn't high tech. It was just guys selling corn on the side of the road. But after a few months, and after a couple more summers, we had up to 25 stands, and we found that we put the front passenger wheel through the floor because we had it overloaded with corn once, and so we upgraded our trucks. Anyway, so I went digging through these, and then I found this is the shot I like. Not only am I young, but the selfie with the piles of cash is a generation after generation phenomenon. Anyway. We liked our business. It was a lot of fun, and I did it while I was at BYU. When I was here at BYU, I studied physics. I just thought I thought it was interesting, and then when it came time to decide what to do, I was involved in a lot of undergrad research, and after a year and a half of doing that and proving that you can't it's really hard to put indium in cadmium selenide nanocrystals. After a year and a half of trying, I proved that you can't. And I wouldn't say it was a waste of a year and a half, but I decided I don't want to do a PhD in physics because sometimes it can be a long road to hoe. So I decided to do something else, and I looked into it and found that being a patent attorney, you're involved in a lot of technology, and you're helping a lot of startup businesses and companies and helping people protect their technology. And so I decided to do that, and I haven't really looked back since. It's been a great career. So if there's anybody interested in that, I'm happy to talk to you about that. And as we talked about this class, I have a lecture and I have some slides to go through, but I don't feel obligated to get through these. So if you have questions in particular, I'm happy to answer them. Generally, I don't know if anybody's gone to the local doctor in their ward between sacrament meeting and Sunday school and asked them to diagnose a digestive problem. Some questions I get, if I get a question from the back row, am I infringing a patent? We might discuss that, not in the larger group, but in confidential space. But I'm happy to answer questions generally, okay? So what we're going to talk about is the first question is what is intellectual property? It's a term people like to use quite a bit. Do you have your intellectual property? Another question is what businesses have IP? Are they just tech businesses? Are they other businesses? And then what are common IP issues for startups? I was talking to a friend of mine that was given a similar presentation up at the University of Utah, and he called them, what are the 7 deadly sins of IP? Being as the venue is at BYU here, I thought what we'd do is talk about the 7 heavenly virtues of IP. So what is IP? Anybody heard the term before? Does it leave you scratching your head, or does it sound just like a really good term, right? Everybody wants IP, right? But IP it's their intellectual property. It's creations of the mind or intellect that are protected or protectable by law, okay? And usually they fall within 4 different categories. And I've listed these. This isn't just by chance that I've listed them this way. The first is trademarks, okay? The second is patents, copyrights, and then trade secrets, okay? So back to the first question, or the next question then is what businesses have IP? If you think about which one I listed first, trademarks, right? Who knows a business that doesn't have a trademark or doesn't have an interest in a mark or a name of their business, right? The business with no name. I don't know if they still make generic products. I remember buying ketchup as a kid that had just black and white on it, the no name brand. Maybe they don't. But even then, it was distinctive, it was black and white, and everybody knew that was a no name brand. So the takeaway is all businesses have IP, whether they know it or not, okay? So as I look back at guys selling corn out of a truck, it's about as non-technical savvy an operation as you can imagine. But here we are, we had a bunch of signs at 25 locations, and so we went out and bought a bunch of bundles of plywood. Spent the whole night painting these signs with our darn fresh corn, okay? So did we have IP? Well, we had a brand that we were using to identify our business, and after one season of this, people knew it was darn fresh corn. Again, it wasn't very sophisticated, but we did have a guy with a spray painted sign, and he decided he was going to start selling darn fresh corn. And we went and talked with him. We told him his wasn't darn fresh, ours was the only darn fresh, and then he quit putting his signs out. So we had IP. We weren't sophisticated. In fact, I'm wearing wooden shoes in this picture. So again, back to what I'm going to do is I'm going to go through what are these? Trademarks, patents, copyrights, and trade secrets. And I apologize, it's a large class. I know that some of you are going to be more familiar with what makes a patent and a trademark. But just to lay a basis, I'll spend a little bit of time, and feel free to ask any questions, okay? So a trademark. Have you heard the term trademark? I got a bunch of boys, and we were on our way out on an adventure, and we drove by a place that had a trademark I didn't think was very good, and I explained it to them, and I explained to them what a trademark is. And so for the last 2 weeks, my kids are constantly looking at trademarks, and they're saying, oh, Dad, that's a trademark. Oh, look, that's got a TM next to it. Oh, that's got the R next to it with a circle around it. What does that mean? And I explained to them what it means, and now they say, oh, look, that's a registered trademark. Just last night, my kid has a Batman cape thing, and it had the Batman symbol, and it had the trademark R, the registered trademark on it. So a trademark is something, once you see them and you start noticing them, if you're into marketing or branding, you notice that they're everywhere, especially if you go to a NASCAR convention or a NASCAR race. But a trademark, it's legal protection for a word or a name or a symbol or a device. The key is that it's used in commerce to identify the source of goods or services, okay? And so it serves two purposes. It serves to protect the guy making the goods, because then it keeps people from making counterfeit goods, right, that are of lesser quality, but he's palming them off as his goods. But it also protects the consumers, right? When I go buy a bottle of Heinz ketchup or Ida potatoes, I know that I'm going to get the consistent product that I always get every time I buy Heinz. But if I didn't have a trademark, then any guy putting ketchup in a bottle could sell anything he wants, and there's no recourse as to where it came from, right? And he doesn't have a lot of incentive to keeping his product high quality. So what it protects is that a trademark protects the standard and stylized characters, but it's broader than that. It can be the graphics, it can be design, it can be a logo. For those that are into this, it can blow your mind. It can be a sound, it can be a smell, it can be a color. Okay, if you think of PBS, that goes dun, 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 that's a trademark sound, okay? And it identifies the news when they come on. Yes?
How do you trademark the smell?
It's tough. It's tough. So a big part of the trademarks is you have to put on, so if you think of like colognes, or Old Spice, or those of you that wear Axe, is that still in favor? Those are going to be so you come up with a unique smell, then you work it out with the Patent and Trademark Office, and you put it on public notice, and people can oppose it. It's a more abstract one, but if you think of like perfumes, that's a good way to protect it. And so you can say, look, this guy's infringing our trademark, he's making our smell. And others can oppose it. They say, well, your smell is really close to my smell, and then it's left to people arguing about whether smells are different. But you can. And even just colors alone. If you think, I remember learning about this one. If you think of an ironing table, your mom's ironing table, a lot of times they have a green cover on it. That cover, just that green cover, in the class of ironing tables is a trademark color. Okay, so it would keep somebody else from coming along. They say, look, it doesn't have a name on it. It's just this color of green, and I'm making the same color. They'd be able to stop them with that. Is there a question?
Yeah. So when it comes to things like smells and tastes or different things like that, let's say like Coca-Cola versus another one, and they're saying that it tastes exactly the same. How do companies argue their case without sharing like the secrets of the trade?
So are you referring to taste infringement?
Yes.
Do you guys remember the commercial with the Coke Zero? There's a commercial where they came out with Coke Zero, and they said it's so much like Coke, and they had their IP attorneys, and they said, what do you think? And they tasted him, and he said, I think you got a case for taste infringement. There's not a protection for, as much as I know of taste, but I think your question makes a good point in that these aren't exclusive, okay? So you could protect something with trademark, and there's also other ways to protect it. So for example, the formula for Coke, I don't know if they've sought protection with trademark. I think smell's hard enough. I think taste would be even harder. But a trade secret would be another way to protect these. And a lot of times you use these different tools, not exclusively, but as a belt and suspenders approach. Okay? Speaking of Coke, the one thing I like about Coke is it's a big company, and they use a lot of intellectual property to protect a lot of different things. And you'll see that there's overlap in some of these things. So if you think through the Coca-Cola products, these you're familiar with, they're registered, just a trademark. It wasn't registered, but they're putting the public on notice that they're interested in reserving their rights in this as a trademark. The bottle itself, the shape of a classic Coke bottle, that became, they trademarked that shape, okay, and it became a symbol for their product. And then in terms of coming to BYU, I looked this up, right? Because again, with what type of entities have IP? Well, who knew the church was interested in trademarks? But they are. Okay, so the CTR is a shield for jewelry. The church owns a trademark in this. Okay, the Church of Jesus Christ of Latter-day Saints, the logo as it is, or even just the character marks, no matter how they're written, the church has a trademark on that. For those of you that are subscribing to the Friend or the Liahona or I didn't put the ensign up, but a lot of these things, the magazines that the church puts out, they get trademarks on. And why do they do it? To protect it from people copying or sending some other magazine calling it the Friend. Okay? But I like this because it shows that it's not just high-tech companies that have IP. All right, almost nearly any business entity.
So if you're starting out your own company, how do you look to see what is a trademark or what's patent related so that you don't have any legalities?
Okay, that's a great question. So what do you do? And I could answer this now. Let me do that. I'll hold on to the question and I'll get to it in probably about 10 minutes. Is that okay? Because that's one of the 7 heavenly virtues of a startup company, okay? And if I don't answer it, then ask me again. Okay, so the point I wanted to make with trademarks also is, when do your rights in a trademark begin? Okay? Do they begin when you register it, when you file for it? Do they begin when you start doing business? Your rights to a trademark begin when you start using. It's based on use. So your rights to it begin on use. Now, somebody else might have been using it before you, and that might become an issue. But your rights to that become vested, or you start gaining rights to that upon use, okay? One thing to take away, if you're not using it, so say you say, I have a great idea, we're going to name this company such and such, but you don't use it, then you're not going to be able to get the rights on that. It's based on use, or an intended use, or you're going to use it soon. Okay, and how long does it last? It lasts for 10 years with a 10-year renewal term, okay? And it can last indefinitely. You just got to keep renewing it. If it becomes generic, like aspirin or a Murphy bed, then you may lose it. If they say, look, this is your mark, but it's become generic, everybody uses that to describe that product, then you could very well not be able to register it on your next term. It's fixed. It's going to be fixed. Okay, the next one is patents. This is the area I deal more exclusively, not exclusively, but this is one of the areas that I really like. So a patent, and I call it utility patents. Usually people, when they think of patents, they think of what are called utility patents. And what that is, it's an exclusive, it's kind of a key word, it's exclusive legal right to make, use, sell, or import an invention, okay? Who grants the right? Typically, it's a federal government that's going to grant the right in a patent, and they do it not just out of largesse or the goodwill of the government. They do it in exchange for something, okay? Because it's a monopoly in your invention as it's claimed. And the trade-off is the federal government's willing to give these strong rights that we call a patent in exchange for an inventor to give a detailed public disclosure of his invention. Okay, so it's not you're getting something for nothing. You got to give that to the public, and it has to be you have to give a public disclosure of the invention. It has to be a new and non-obvious invention. Okay, so what that will protect is it'll protect machines, processes, manufacturers, things that you make, compositions, chemicals, uses of chemicals, and new improvements. And how long does it last? Well, it lasts generally 20 years from the date of your filing your patent application. Okay, so it's shorter in time. If you think about a trademark, it can keep going and keep going. Patents, they're very strong, but they don't last as long. Okay, so just as an example, if you go to Google Patents down the road, if after this you think that lecture was just phenomenal, I really want to start reading up on patents more, you can go to Google Patents. There's millions of patents, right? And I think it's real interesting. It's this huge database of information that we've got from inventors, and they've given these disclosures they probably wouldn't have given if they didn't have the hope of getting a patent protection for it, okay? And this is what a patent generally looks like. One thing to look at, as you're looking up there, is if it's got that number right there, see that? Then you know you're dealing with a patent, okay? And this is to Coke, and this is a dispenser for a beverage including juices, okay? I'm not going to bore you with all the details of this. I haven't even read it through myself. But if you look up here, then you know you're dealing with a patent. Now, what if you're looking through Google Patents and you come across something that looks like this? It's got the same figure. It's assigned to Coke. What is this? This is a patent application publication, okay? The easy way to tell is you look at this number, and there's the publication date and the publication number. And what this is when you file a patent application, The federal government, the patent office, they'll take it, they'll bring it in, they'll say thanks, and 18 months later, unless you request that they don't publish it, they will publish it. They'll make it publicly available. And so this is not a granted patent. These guys hope that they'll get a granted patent, but it's just a published application. Okay. Okay. So the next type of patents are design patents. What's a design patent? It's different than a utility patent because it's similar in that it's an exclusive legal right to make, use, sell, or import, but it's different. It's to make, use, sell, or import a new, original, and ornamental design for an article of manufacture. I like these. I used to do tons of these for a Japanese company that made a lot of consumer products, okay? I used to do a lot of these with Sony. And it was fun because I'd go to work and I would argue about why the PlayStation handle that they had was different than other handles for video game controllers, right? Who wouldn't mind doing that for work? So a design patent, it covers an ornamental design. It lasts a little bit less than a regular utility patent. It lasts for just 14 years from the date of the grant. So you might be wondering, what do these cover? Who uses these? If you're Coca-Cola, not only do you get a trademark for the bottle, but they got a design patent on their bottle. Okay, so that's a little bit of overlap. They protected it with a design patent. Another one is, I just looked at this, so for you consumer or Apple guys, here's a design patent that Apple just got for their Apple Watch. Okay, so if say you're Dodge and you're spending a lot of time and energy and coming up with a sweet grill to put on the front of your truck, how do you protect that? A lot of them use the design patents. If you're making Nike shoes or Adidas shoes, how do you do that? Those guys file like crazy. They're design patents, okay? They're different than utility patents, and they usually go through the patent office quicker. And so it's a way to get faster protection, and it's quite a bit cheaper.
So I understand the clear difference between a utility and design patent, which is like a hard good.
Mm-hmm.
Can you give us an example of one of each for a software?
Well, okay, so for software, let's go back to how I defined it. So the software is going to be a little bit tougher because it's an ornamental design for an article of manufacture. So unless you're producing something with something visible on the outside of it, or it has a certain shape to it, then you wouldn't want to protect it with a design patent. So if you were putting code on a poster and it was just beautiful ornamental code, then it might. But usually your software is going to be covered in a utility patent where it's going to be described more often in terms of a method. We do this, and then we do this step, and then we do this step, and then we do this as a final product. Does that answer your question? Okay. Okay. So design patents, they're fun. Okay, what makes a copyright? This is one I think people are pretty have heard, or maybe it's because we like digital music. Okay, but a copyright, it's legal protection for an author's work. Now this is a key word. It's original work that's fixed in a tangible medium. Okay, it has to be fixed in a medium. Tangible medium means something you can see, something you can touch. So what is it? We use it to protect literary works, dramatic works, musical works. Software code is another way, but the description of it's going to be more narrow because it's the actual code that you're using. So those of you that are involved in coding, there's a lot of different ways you could code for something and get the same end product. And so if you were to, you can get the same result, but not fall within the guy's copyright. And so it's a way to protect software code, but it's narrower. And also it covers derivative works, okay? And in general, the term of it is the author's life plus 70 years, okay? And then, that's kind of a key. It has to be fixed in a tangible medium. So getting back to our Coke example is if your Coke, see now look, this is similar. There's some overlap here, right? Because we have their registered Coca-Cola mark, but they've made a poster, okay? So that's fixed in a tangible medium. Or they might make a sweet video of the dude that doesn't have a shirt on. But that video is going to be protected by copyright. Or if they're back in the 19-teens, they might make a sweet Coca-Cola song and they distribute the music that goes along with it. And that would be covered by copyright. Another example with the church, one of the ways that they protect it, say somebody takes the church handbook of instructions, puts it up on the internet. One of the vehicles they have to recover that and have them take it down is that's the distribution, unauthorized distribution of a copyrighted material. When do you gain a copyright in something? Do you have to register it to have a right in it? No, your copyright, kind of similar to a trademark, is once it's fixed in the tangible medium, the author has a copyright in it. To go enforce it, he needs to register it, but he has that right. Okay? Any questions about copyrights? Not confessions of infringement, just.
Like sometimes you might make a video and you want to put somebody's song to the video, the song can be copyrighted, but you can get permission to use it sometimes. Is that
You could.
with the copyright you can get permission sometimes?
Right, if you have a written license, then that, really a lot of times a license is a promise not to sue. But yeah, you could come in a license.
Probably like the most famous example I know of copyright is like Mickey Mouse. Like Mickey Mouse has lasted for like such a long time, right? How is that happening?
Well, so that's, Disney's got a very vested interest in prolonging these copyrights, and they are coming up. So one of the things you can do if you're Disney is you can lobby the heck out of Congress to have them extend the term, right? And it's a hard sell because they're saying, look, we want this monopoly on this work that we have. What's the trade-off that the public gets by extending the term, right? It already came up to 70 years, and they said, okay, that's a good trade-off. Not only will it provide for the author, but it'll also provide for the life. It's 70 for a reason. It's the life of his kids, was the idea of it. So Disney can try. I think they've tried to push it up to 110 years, and it's created a lot of issues. Another way they say, well, okay, this is going to die, but maybe trademarks is the way. So now they say, okay, if we put the Mickey Mouse, face or logo or whatever, we can use that as a trademark. And so there's different ways that they'll try to protect it. But yeah, that 70 years is problematic if it's a good seller. Okay, so trade secrets is an interesting one, and I think this is probably one that, similar to trademarks, I think you'd be hard-pressed to find a business that doesn't have trade secrets. Who doesn't like a secret to have, right? You'd hate to be the guy that doesn't have a secret. What is a trade secret? There's some kind of key elements of something that makes it a trade secret. A trade secret is information that's not known by others. Okay, secret. It's not known by others, and those that have the secret take reasonable efforts to protect the secret. And not only is it a secret or what we'd call confidential information, this information helps the business gain an economic advantage over their competitors. Okay, so it's not just a secret like, I don't know, I didn't take the trash out, but don't tell my wife, right? It has to give you an economic advantage over your competitors. What does it protect? It protects a lot of things. It protects, for example, your formulas. Any information a company has that you wouldn't want your competitors to have. Okay, methods, designs, data, algorithms. If you worked up a trading algorithm on pork bellies, and it has all these variables, it plugs in it tells you when to buy and sell pork bellies. Yeah, if you're taking reasonable efforts if it's making you money, and you're taking efforts to protect it, then that would be a trade secret. Software may fall under this. Really, any invention you can keep as a trade secret. Customer lists, contacts. So, for example, going back to Darn Fresh Corn, I had a list that had taken me years to put together of where we could sell corn. I had a whole list of employees. We had 50 employees at the time. We had a whole list. It took a lot of work to put that information together. If somebody came into the corn business and they said, if I can just get this guy's list, then I could go and pitch his customers. I could go get his spots. I could get his employees, and I could get his contact for the corn. I had a list of corn guys I'd buy corn from, who was good, who was bad. If they got that information, that could really hurt my business. And so I didn't realize it at the time, but I kept this information in a notebook, and I kept it in my bedroom, right? And I always thought, well, that'd be a bummer to get that out. I wouldn't take it out of my house. And I didn't know that's a term for it, but it was a trade secret that I had. So again, another non-technical savvy business that has IP. I just didn't know it. How long does it last? It'll last as long as you can keep it a secret. Okay, so say the Coke formula, okay? So they could say to themselves, well, okay, should we get a patent on this, right? And they could get a patent, and it'd be a really strong right, but then after 20 years, it would be available to the public and anybody could do it, right? So that's the trade-off. Is if you disclose it, then you get a really strong right, and you don't have to worry about somebody stealing it, but it's out there. and then after 20 years, your term's up. If they can keep it a secret, they can keep it in perpetuity, okay? So trade secrets is something to think about with a company's IP. One of the phrases that people like to use is if it does get out, for example, and this happened, a disgruntled Pepsi employee thought he came across the Coke formula. Or no, I think it was a disgruntled Coke employee approached the Pepsi guys and said, hey, I got the formula for Coke. And what does Pepsi say? You know, I don't want to touch that with a stick. Stay away from us, right? Because they know this guy is, they'd get in trouble if they're acquiring his trade secrets through improper means.
So what kind of legal recourse is associated with a trade secret if it's only indefinite as long as you can keep it? Some
Right.
things that can you, like, what kind of-
Yeah, so it's more limited. A lot of times it's going to be limited to a contract, right? So if you have an employee contract and you got to keep this data or this software confidential, and he goes and discloses it to your competitor, then you can sue the employee, but chances are he's not going to have as deep a pockets as it did you harm, right? And so you can go after your competitor that got it if he got it through improper means, but maybe he didn't get it through improper means. Maybe he came across it in a way that he shouldn't have known that it was a trade secret. So one of those things that goes along with these is once the toothpaste is out of the tube, you can't put it back in. Right? So you can do that. Did you catch that? Injunction or lost profits.
Yeah, I guess the question is why would somebody want to register a trade secret if there isn't a lot that they can do with this box?
Why? Sorry, say it again. So why?
Where would that
So,
be registering?
okay, so with trade secrets, you don't register.
Okay, so this is not associated.
Yeah, you keep it under lock and safe. Yeah, so it would only come out if it got out, right? You'd only litigate it or try to pursue it legally if it had gotten out. But you wouldn't, yeah, there's no registration. You keep it secret to yourself. Does that make sense? Okay. So, trade secret is real interesting. In the cases on this, I mean, one of my favorite cases is there was a plant in Pennsylvania. Guys were making methanol, right? It's really hard to reverse engineer a chemical process if you're just ending up with something that's already available, some commodity like methanol. And they were flying airplanes above it, taking pictures of it, right? So they were, and then the question is it reasonable to put like a 5-acre roof over your whole chemical compound to protect your trade secrets? Anyway, so you have to take reasonable precautions. You can't, in another case, they got their customer list, they're throwing it out with the trash in the dumpster, and somebody comes along and finds it, right? Well, was it a trade secret, or were they taking reasonable precautions to protect it? Okay, so, again, examples, formula for Coke. They might have a distribution algorithm, how to get the Coke and make sure it's on the shelf in the places we need it before demand's actually there, right? The method of processing high fructose corn syrup, right? They might just say, hey, look, we got a great recipe on how we make high fructose corn syrup. We're not going to patent this. We're just going to keep it in-house, keep it a secret. So for the rest of the time, what I would call the 7 IP virtues for startups, okay? Again, different than the 7 deadly sins in name only. But these are things to consider if you're in a startup or really any type of business, okay? And I'll go through each one of these individually, and it's funny, as I was putting this together, I felt like King Benjamin, where he says, you know, there's so many ways to sin, I'm not going to number them. Anybody recall coming across that? Anyway, not to scare you, right? But there's a lot of IP considerations to think of. But if you start with just keeping these 7 ones in any startup business or business that you're working in, these are great ones. You'll do pretty well, okay? So the first 3 are just general: ownership, interacting with outsiders, and 3 an overall strategy. 4 and 5 fall under trademarks, searching and branding, and 5 registration. And 6 is statutory bars and potential and willful infringement, okay? So, I hear typing. I think, will this be available, the slides? Okay, so you can type, feel free to type. But I think this will also be available. Okay, so the first question is, so you and your buddy, you got a great idea, and you're going to start a company, right? You're going to form an entity, however you're going to do it, and you got this great idea that's going to be based on this idea, right? One of the issues is who owns the IP, Okay, now I'm just going to put up a list, but don't get distracted on the list. So one of the first considerations, a lot of times people have their idea, but it's not in a vacuum, right? Like, hey, I used to work at this software company, and we would make software that would do X. And while I was there, I had this great idea, and I'm going to start doing this X that's really similar to what we were doing at our software company. But I'm going to do it on my own, so we're going to form our own company, okay? And so you partner up with a guy that's doing that. One of the issues is, well, does he have the right to his idea? Did he come up with this, or did he develop it while he was at work? Is it related to his work? A lot of times, it's similar to where he was working, right? So that's one thing just to think of. And I made the joke about diagnosing a guy with a digestive problem in Sunday school. I'm not talking about anything in specific. These are just issues to think of, okay, when you're starting up. And then if you want more specific answers, then you can talk to, often it's helpful to talk to an attorney and say, look, here's the issues. I remember hearing about ownership. Here's why I think ownership might be a cloudy issue. What do you think about this, okay? So the founder, does the founder own the IP, or does the founder's former employer own the IP? Another question is, what if instead of branching out right out, you're moonlighting with your new business, and it just happens to be in the same technology that your day job is in, right? Now, you're a good, upstanding, good faith acting citizen, right? But it's hard to come up with ideas very similar to what you're doing at work and not have it look like you're stealing these ideas, appropriating these ideas from your work, right? That's, if you put yourself in your employer's shoes, what would it look like to him? Okay, these are just things to consider. So the founder's current employer, could he claim that he has some of that interest in that IP? Now, along those same lines, has there been an assignment of the IP? In a property law class that I had, the professor, he liked to say, you can't, well, it's really hard to assign what you don't have, right? So first of all, is a lot of times when a business will start, the founders will assign their IP to the business in exchange for perhaps like shares, okay? But can he actually assign it? Does he actually have it? That's a good question to ask. What if you have an employee that says, hey, I got these really great ideas, I want to help your company out with it, and I want to contribute these to your company? That's good, but is he obligated to assign those to you or not? A lot of times that'll be in an employment agreement that you have with the employee and the company that he's working for. What if you bring in an outside consultant that gives you some great ideas, tells you how you can do some things? Who owns the IP to that? Once you start using it, does he have the IP to it? Or did he give that to you by consulting with you? And a lot of these questions can be resolved with an agreement that you sign with him beforehand. Same thing with an advisor, a mentor, or an independent contractor that comes in and gives you some great ideas. Where do these ideas come from, and were they obligated to give them to you? Or maybe they were just giving you some ideas and they actually felt like they owned the idea itself. What if you collaborate with other people and they build on your idea and they give you some improvements? Who owns those improvements? These are good questions. So in a lot of ways, good contracts are ways that you remove a lot of the doubts or questions with these. So if you have an employment agreement, if you have some employees, it's good to look at your employment agreements and see if they protect the business or whether they let the employee walk out the door with the IP that he's developed. Another question is if you're involved in licensing, whether you receive or take a license. Is it an exclusive license? Is it a non-exclusive license? That's based on what you negotiate and what's in the agreement. Is it regional or is it national? Are rights granted back? Is it transferable? You know, any IP that you have by licensing, these are questions to ask. Okay. Another thing to think about is if you're obtaining the basis of your code from an open source, and then you build on that, and then all of a sudden you feel like, well, I came up with this. By using the open source, did you forego rights that you could have had if you came up with it on your own? Okay? Any questions on ownership? Back row.
So how much would it cost to like insure your rights, trademarks or copyright? I'm just curious about the cost.
Okay. So you mean like registering?
Sure.
So copyrights, if you're literate, you can do it on your own. It walks you through the copyright website. It can be like tens of dollars to get a copyright. It takes anywhere from 8 months to a year. Trademarks, that's kind of where you're starting to walk into wanting an attorney to help you, that they can help describe your class and determine your class a little bit better. You can do it on your own if you're strapped for cash, you think you're smart.
Was it $325 or is it $350?
The filing fee is like a few $100, like $300. If you pay me, it's $1,000 for first class, $500 for each additional class. And we handle everything from like start to finish. We talk to you about what your mark is, and usually go after, if you're going to be a startup, just do your standard character mark. If you think you got your logo locked down, I promise you don't. Wait a few years. But it costs about $1,000 per month.
Okay, you feel good about that? Yeah, that wasn't like an offer and acceptance type thing, by the way. Okay. Okay, so and we have limited time. I want to, because that's been asked about twice. Interacting with others, I'll be quick on this, okay? So say you're a startup company, you got some great ideas, you want to go talk to somebody and they say, well, let's do a non-disclosure agreement, okay? How many of you heard of that, a non-DA or a confidentiality agreement, okay? I'm not saying you shouldn't do them, and I'm not giving legal advice. I'm just telling you there's pros and cons that come with doing a non-disclosure agreement. One thing to think of, if you think about these, is to ask yourself, if you're a Hollywood movie studio and somebody sends you a script, consistently, well, this is back in the day when they used to send scripts in hard copies, right? But they would, without fail, just send it back unopened. Why do they do that? Anybody?
Because there's legal issues that if they decide to start reading, they have issues with the writer who maybe after they decide to change it in a certain way.
Right. Right. So they have 100 writers, right? Cranking out ideas, working on. What are the chances somebody sends in, they have this new plot that's never thought of before, and the Hollywood studio is going to take it and go, wow, this is unheard of. We've never come across anything like this before. It's probably more likely that that plot is somewhat analogous to some plot one of the writers is already working on, right? And so if they accept that, then they give the presumption that they're basing their, that they've used that and they've built on it to make a movie, right? But if they send it right back, then they can deny any assertions that no, we took your idea. It's easier for them to say, no, we had this idea weeks ago. Our writer was already working on something similar, okay? So just think of the movie studios. If you think about non-disclosure agreements, one of the things to think about is saying, one of the problems with them is they might come to you, you might disclose to them ideas, and you put them at risk of you thinking they're taking your idea, and they think you're taking their idea. So how do you address this? One of the easiest ways is filing a provisional patent application. Then you file it with the patent office, your idea, your invention, and then a third party has in their hand a time-stamped application. And that's the way that it really protects both parties, because you can say, look, we signed this non-disclosure agreement, and as evidence that I had this, look, I filed this months in advance of that, okay? Another thing to think about is his company confidentiality security protocol, right? What was it? Loose lips sink ships, for those of you that were on during World War I. And good record keeping within a company, okay? These are ways that you can protect yourself. An overall strategy, I'm going to go through this a little bit quicker, but these are just things to think about. Should you file a trademark? I hope most people would have enough confidence in their business to think that would be a good idea to protect it, just the name. Do you want to use patents or trade secrets? Utility or design or both? How would you monitor your IP? One of the things that people always think about is, well, if I file a patent, who would I sue, right? But really, only a few patent cases end up in court and you get a decision on them. Most of them, it's a way to put a no trespassing sign on a piece of property you feel like you have, right? Few businesses say, hey, you know what I'd really like to land myself in is a really hot piece of litigation, right? Anybody looking for a litigation? People look for litigation like they look for another hole in their head, right? So when you file a patent, a lot of times it's just a way to tell people this is my property, right? And most people will look at it and say, well, he's got a claim to that. Well, maybe we don't want to go into that space. He's got a claim to it. So I like to think about it more as a no trespassing sign as opposed to like a gun or something to stop a guy from taking your idea, okay? Because a lot of people, and I say this because I work with people that say, hey, we'd like to enter this space, but we know about these patents. And we look at it and we might counsel them and coach them on that, but we do take notice of it, and the patent holder is likely never even going to know that that potential competitor was looking at what their patents were, okay? Costs. This is a great one to think about with your IP strategy because, like I said, with my parents and with my own businesses is you know, similar to holes in your head. You're not looking for places to spend more money, okay? So cost is a very real thing. Searching and branding. The best thing you can do for a trademark before you become emotionally or economically involved with it is search around. You can search on Google. You know, you think about it nowadays, it's so much easier. Back in the day, there could be 2 different burger joints with the same name, and one's in Louisiana, one's in California. Now it's easy. You can get on the internet and search. You can search the USPTO's database. You can search your state's listing of corporations and LLCs. You can search for domain names. That's probably one of the biggest, easiest places to gain intellectual property that's good, is do a good search. The question is, do you want to have to rebrand? And we see it over and over. Guys will say, I got this company, they become involved, they form an entity, and then 6 months later they say, dang, we actually been using these guys' trademark. Okay? You want to avoid that. Registering it, that's the only thing. It's relatively cheap, and nothing says that you're serious about the name of this company and this entity if you're registering it. The other 2, statutory bars and potential and willful infringement. I'm just going to leave these here. There's a Q&A session we can do afterwards, but we've run out of time. So thanks for coming. I think is my clock fast?
No, you're just right on time.
Okay.
Thank you very much.